Ma'am.
Awesome. All right, we can go ahead and get started. My name is Janice. I am the marketing content coordinator over at Zane Credit Union, and I'm also one of the financial coaches as well. So if you have any questions about credit, creating a spending plan, budgeting, improving your credit score as well, feel free to reach out and I'll drop my contact information in the chat box below as well. So you have that. Um, a few housekeeping rules as well. If you don't have a video on, that's no problem. If you want to turn it on, feel free to do so, as long as your mic is muted so we're not disrupting other attendees as well. If you do have any questions, feel free to put them in the chat box, or if you want to wait till the end of the presentation, whatever one's convenient for you. We'll be answering questions along the way. And with that, we'll go ahead and get our wills and trusts presentation started. I have the pleasure of presenting Frank Danzo, who's an estate and elder law attorney. Frank, with that, I will hand it over to you.
All right, thanks, Janice.
Yeah.
Well, welcome everybody to the Wills and Trust class. My name is Frank Danzo. I'm an elder law and estate planning attorney. And in May here, I'm starting my 30th year doing this, believe it or not. So when we talk about estate planning, wills and trusts, and elder law, generally we're talking about trying to minimize the costs, minimize the hassles, and minimize the problems when something goes wrong, usually in the areas of death or incapacity or disability. So it's never anybody's favorite topic, but it is something that we all face at one time or another. And as with most things in life, it usually goes better if we do a little bit of planning. Let me close this because it's just going to keep beeping all night. That's my email there. So tonight, we're going to look at some of the issues we face in this area. Generally, the big three that we talk about are estate taxes, probate, and incapacity or disability. We will touch on all of those. We will look at our common tools that we use to address those, which are wills, powers of attorney, and trusts. And then we will look at a couple of the hot topics. And then I usually save some time for about 5 or 10 minutes at the end to answer questions. I will also say you guys can ask questions as well. I do like to have some back and forth. So I recommend, given that we're doing this by Zoom, that we put them in the chat box, and then I will try to answer those as we go the best I can. Okay. But I'll also do some questions at the end, depending upon what's going on. You will all also at the end, Janice has some materials for you. She will send out, we've got an organizing your legal affairs packet that's about 30 pages that has quite a bit of good information on how stuff works in this area. It's as complicated as ever, just like everything else. It also will include an opportunity we will talk about how the issues and the options generally apply to people. But as part of coming to the class, you also have the opportunity to do a 30-minute meeting with me at no charge, where I waive my regular consultation fee, and we can go over how this stuff would apply to your individual situation as well, and give you some different options and things like that. Okay. So we'll go ahead and get started. Excuse me. The first topic we're going to touch on an issue is estate taxes. Okay. Who can tell me how much are you allowed to leave right now today in the state of Colorado without paying estate taxes? Who has a guess? Throw it in the chat box.
You said how much can we leave without having to pay taxes?
Yep. It's probably more than you think.
0.
Well, no, estate taxes. So estate tax.
Oh, okay.
Would that be for our kids? Is that what you're saying? If we leave?
Well, it comes out of your estate. So estate tax does not come from the recipients. It comes out of your estate, and then the recipients get what's left over.
Oh, okay.
More than 10,000. I'll just jump right to it. It used to be $1 million, then it went to 5, then it went to 6.5. Right now it's 13.1 million. How many people are over 13.1 million? Sorry, I'm not over that. I'm just showing raise my hand if you wanted to do that. I do not expect there to be anybody raising their hand. On average, I would have to be Zooming with about 10,000 people to have one person raise their hand, because 99.99% of us are below the $13 million limit. Okay. So this is not a huge problem. This is the federal estate tax, which is nationwide. Currently, 99.99% of us are below it. However, in my 29 years of practice, they have changed the estate tax 21 times. They have tried to change it in 2021, 2022, and 2023 back to $1 million exemption. They have just failed each time. So it's probably going to change, not this year, given that we have the election coming up, but whoever wins in November is probably going to try to punish whoever loses, is most likely what I can figure out. So realistically, we'll probably see some kind of change in this next year, one way or the other, depending upon who wins. Okay. Colorado currently has no estate tax. Ours expired about 10 years ago, and we have not enacted a new one because of Tabor, our constitutional amendment that says no new tax on the people without a vote of the people. That's one of the reasons you're seeing all that property tax stuff that they're trying to do with the property taxes. It's hard for them to pass something because you're not supposed to increase or change the taxes without a vote of the people. So they're putting different ballot initiatives out there. That's one of the examples. The estate tax hasn't even made it on the ballot for the last, I don't know, 4 or 5 years. They haven't been super worried about it lately. We'll see how that goes. You never know.
Are you open to a question here?
Yeah, sure.
I don't even know what you mean when you say estate tax. Is this the amount of money we can have before we're taxed, or are we taxed up to 13.1? Are we
No,
taxed?
everything over that.
Okay, I don't know what you mean when you say estate tax.
Yeah, it's the federal estate tax. So it
Well,
applies to every U.S. citizen, and it used to have a limit of 600,000 when I started back in 1994, and it's went up to 1 million, and then it went up to about 3.5 million. Then it
no, I
went-
understand the fluctuations.
Yeah.
Is that where taxing begins, or is that where taxing ends? Is, what does that mean when you say estate tax? Is that your total value? And then the
Yep.
taxing
So you-
starts? I don't know
Yep.
what it means. Sorry.
Okay, well, we got that. So it means that you pay 55% tax on everything over whatever the exemption is. So whatever amount the exemption is, if you have more assets than that, it's the total of everything you own, including your house, cars, life insurance, you name it. If you go over the limit, you pay 55%. Sorry, it comes out of your estate and your heirs get whatever's left over. So that's what the estate tax is. That is federal law. It's been around for, I don't know, since the 50s or so, something like that. And like I mentioned, they tried to change it back to 1 million 3 times in the last 3 years. If they change it back to 1 million, we would probably have somewhere around, goodness, 15% of people over 1 million, because it includes life insurance and everything you own. And if you had to pay tax at 55%, it's a terrible, terrible tax. So if they change it, you'll hear about it and you'll know, because it's usually national news and it's a big deal. Most likely it won't go all the way back to 1 million, even if they do change it. It is actually set to go back next year to half the amount, 6.5 million, automatically, but they'll probably change it once we figure out who wins the election. Okay. So it's not a huge issue for people today, but you want to keep an eye on it. Like I said, if it goes back to 1 million, it's going to be a problem probably for a lot of people. Second problem, much more common and much more of an issue, and that's probate. Everybody worries about probate. Everybody worries, oh my goodness, what are the cost and how do I avoid probate? What is it? All of these things. It's probably one of the most misunderstood processes out there. Probate is the process of getting whatever's in your name that you own out of your name when you pass away and getting it wherever it's supposed to go. Okay. So in Colorado, it takes place in the county court in the county where you live when you pass away. If you have a will, we submit your will to the judge in the probate court. The judge looks it over, makes sure it's valid. If it is, they issue an order appointing your executor or personal representative, as we call it in Colorado, who goes out and gathers up all your stuff, pays off your debts, and distributes whatever's left according to your will. If you don't have a will, we do the same process. We just use the state statute. It's called the Colorado Probate Code. It's got about 400 pages. Not ideal, okay? In Colorado, we have what's called simplified probate. So you will hear people say, oh, Colorado probate's not that big of a deal. And I would agree, it is probably simpler, cheaper, and easier than almost anywhere else in the country. However, I do it 50 times a year. I've done it 50 times a year for the last 29 years. Right now, an average one as a starting point probably runs about $15,000 to $20,000, takes about 9 to 18 months. If we have problems with beneficiaries, creditors, assets, whatever's going on, it will go up from there. If a downtown firm gets a hold of it, it'll be 100,000 or more pretty routinely and go up from there. If you're in California or New York, it's going to start at 100,000 and go up from there, pretty routinely hit $150,000 to $200,000. So yeah, Colorado is easier and cheaper at 15,000 to 20,000, but for most people, is that a big deal to you? I would argue it probably is. So for a lot of people, how do we avoid probate? That's why they ask about it. I do it 50 times a year. Nobody comes out going, yeah, that was great. I'd like to do that again. I really enjoyed that. They mostly say, why did it take so long? Why does it cost so much? Because we have to follow all these statutory things and go through the court system, and going to court sucks. So just like everything else, it's gotten more complicated, more expensive over the years. When I started 29 years ago, it was probably about $4,000 or $5,000. Now it's 15 to 20. So it's up about 4x, 400%. I know a lot of things are up. Most of them probably aren't up 400%, but that's what probate is. So probate is not a tax. It is not a trick. It is not a trap. It's not the government trying to get you. It's just a government bureaucratic process that takes time and it costs money. So a lot of people want to look at ways to do that, and we'll touch on some of those as we go. Okay, let's see here. Deb's got a question. If we have a will already, are you stating that it will still take 1 year of probate? Yes, I am. So wills do go through probate. That's one of the common misconceptions. That's what your will is. Your will is the instructions to the judge in the probate court on what to do when you pass away. Who's in charge, who's the executor or personal representative, and who gets everything. We'll talk about that a little bit more as we get along, once we get into our tools and the wills, okay? But yes, it all goes to probate. Third problem I want to spend a little bit more time on, though, and that's incapacity or disability. Has anybody in here ever known somebody who was legally incapacitated, or you yourself have been legally incapacitated according to the laws of the state of Colorado? Anybody? You can raise your hand if you're on video. You can say a thumbs up or a yes in the chat video or whatever you want to do there. Anybody? I got a no, thumbs down. I see maybe one hand there. I should see every hand in here. Why? Was anybody in here born 18 years old? No, right? So if we're under the age of 18, what do we call that? We call that being a minor, okay? That is one type of legal incapacity. You are not allowed to own property. You are not allowed to make your own decisions. Who does that for you?
Parents or
Parent,
guardian.
right?
Yeah, parents or
that's
guardian.
right.
Yeah.
Yeah, your parents who are your guardian. That's right. As we get older, they're doing a better job of keeping us alive longer, but not always in tip-top shape. So if you have a stroke, heart attack, develop Alzheimer's, dementia, fall off a ladder and hit your head, car accident, you may end up legally incapacitated to where you can't take care of yourself, can't take care of your assets. If you don't have a plan in place, the default to take care of you and take care of all your stuff is to go to the same probate court where we go to probate your will and your estate, and we have a guardianship for you and a conservatorship for your assets. Okay. Each of those processes, same probate court, similar process, but we got two of them, one for you, one for your stuff. When you pass away, you're gone. We're down to just your stuff, right? So each of those takes about 3 to 6 months, about 15 to 20 grand. It's a little bit more extensive because you're still alive, you're still here, and we got to deal with you. It's a little bit more serious than once you're gone. So now we're talking about $30,000 to $40,000 baseline, and then it goes up from there, depending upon if anybody argues over who's in charge, how you're cared for, how your assets are invested, or how they're being spent. Okay. In addition to the cost, we're talking about taking away your right to make your own decisions. You can be happy about that. Probably not, right? If you've been making your own decisions for 60, 70, 80 years, probably not going to be happy. And who's most likely going to be doing this? Your spouse or your kids, right? Even your spouse does not automatically have the right to do whatever they want with you and all your stuff. Why is that? Well, number one, we're all supposed to be autonomous. We make our own choices, right? So no person has the right to do whatever they want with you and all your stuff. But we also have a 56% divorce rate, which means if your spouse could do whatever they want, we'd have some real potential problems of people being taken advantage of, right? So you can give your spouse the ability to do those things. That's how we do planning. And your spouse is the first priority when we do go to court. They're the highest priority, but they still got to go through the process. Still takes the time and costs the money. That's your default. Okay. So what we're talking about is a procedure where you get to go to court and pay tens of thousands of dollars to argue with your family. It's not a fun process. Okay. But it's the default. And so a lot of people look at how do we get around that? And I'll tell you this, a lot more people should be looking at that and should be concerned about it. So when we talk about how many people plan for this, we know 70% of people do no planning at all. Of the 30% that do plan, less than half of those plan for incapacity or disability. So depending upon who you talk to, it's somewhere around 10 to 12% of the population plans for incapacity. Okay. And when we say that, what is that? Oh, that's the elder law side of things. So when I started 29 years ago, there was no such thing as elder law. It was called estate and trust. Everybody was concerned about what happens when I die, right? Where's my stuff go? What happens? About 15 to 20 years ago, people started realizing, whoa, we got all these people. They're living longer. They're taking care of stuff, or they're still here, but they're incapacitated. We're keeping them alive, but they can't function as well. And some of it is a function of you can have an illness, an accident, a chronic condition, Alzheimer's, dementia, MS, Parkinson's, whatever. But I can tell you, some people hit the wall at 60, some people hit the wall at 70, some hit the wall at 80. Everybody hits the wall at 90. If you get to 90, you can be perfectly healthy. You just don't move that fast. You don't think that fast. You really shouldn't be driving. You're probably not going to be able to handle your finances and all that stuff. It's just the way it is. You're basically spending all of your energy just trying to stay alive every day. That's what you do. So if we're lucky, we get all the way to there. Yay. But a lot of people have stuff happen before then. It's about, depending upon who you talk to, about a 55% chance that you're going to become incapacitated for 6 months or more at some point during your life. That's worse than flip a coin, 1 in 2. Let's put that in perspective for a second. Anybody in here play the Powerball? I think we just had another $1 billion jackpot like a month or two ago. I know I missed it. I usually play when it's $1 billion. What are the odds of winning the Powerball? Really bad, right? 1 in 293 million. You have a better chance of being struck by lightning twice than winning the Powerball. And they say lightning never strikes twice, right? You have a better chance of being struck by lightning while you're being eaten by a shark than winning the Powerball. And yet, to get to that $1 billion jackpot, you got to sell 2 billion tickets. We only got 325 million people in the United States. So you got to sell 6 tickets for every person in the United States to get that jackpot. Every person in the United States got to buy 6 just for that one jackpot. That's a lot of people playing the Powerball, where you have to be struck by lightning while you're going to be eaten by a shark in order to win. If you're going to have a 55% chance you're going to become incapacitated, flip a coin, 1 in 2, you would think more than 10 to 12% of people are planning for that, but they're not. Okay. So that's part of my job, is to educate people on why this is important. And we'll get into some of the tools, including medical and regular powers of attorney here in just a minute. Okay. All right. So we've got our 3 problems. What do we do? What do we have available for us to deal with those? The 3 tools we use: wills, powers of attorney, and trusts. How many people have a will? I see 1 hand. Okay. Maybe a couple hands there. Okay. iPhone 13's got their hand up all the time, but I don't know what that means. All right. So if you've done any planning, will is probably the tool that you have. It's the most common one. It's the starting point that most people talk about. We've touched on wills. Wills are the instructions to the judge in the probate court. They say who you want to be your executor on Colorado personal representative, and they say who's the beneficiary who gets everything, okay? We've also touched on the fact that wills do not avoid probate. They are part of the process. They are a very important part of the process. Wills came from the Statute of Wills in England in 1244 AD. Excuse me. And interestingly, people think that probate and the will process is designed to protect them. And it is. It's designed to get your stuff to your heirs in an orderly manner. But it actually came about 800 years ago because the judge and the king wanted to make sure when they came to the door to collect the taxes, there was somebody to answer the door that was in charge. So when the king was trying to fight the Crusades in the 1200s and they would go to the door and say, hey, we need gold, you got to pay your taxes. If somebody passed away, the people would say, oh, we're sorry, the owner passed away. We don't know who's in charge. We don't have any money to pay the taxes. And so the king came out with the Statute of Wills to make sure somebody was in charge and to keep your stuff in circulation. We still have that today. Yeah, the government wants your family to get your stuff, but what they really want is your stuff to be in circulation in the economy. They don't want it sitting there frozen because nobody knows what to do or who's in charge or how to deal with it. And so they want that stuff circulating in the economy. I think they call it the velocity of money. Every dollar in circulation creates like $32 worth of an economic value or something like that. If it's sitting under your mattress or it's sitting in somebody's thing because they're dead, it doesn't do anything. Okay. Excuse me. So that's why they want probate to be that way. Okay. Yeah, they want your family to get what they're supposed to get, but they also want to keep it in circulation. So that's what wills are intended for. We've had them in this country for about 250 years. We came from the English system of laws. That's why it's that way. Okay. I have a will, but need to change my executors. Okay. Well, we can certainly talk about how that works on updating things, why you would do that and when you would do that. Do you need to have a will and a trust? We'll talk about that. Usually if you have a trust, you would have a will, but most people, you either pick a will-based plan or you pick a trust-based plan. So we'll talk about that a little more once we get onto the trust, okay? So how many wills can you have during your lifetime? As many as you want, right? Which one are we going to look at? The last one you write, because we know you can't change it anymore after that, right? So we don't care that you wrote 50 different wills. What we care about is the last one, because that's the one you can't change anymore once you pass away. That's the one we're going to follow, okay? And wills do not avoid probate. So if your will only takes effect when you die, what do we use while we're alive? Well, we got to use our second tool, and that's power of attorney. Power of attorney is a document where you give someone the power to act on your behalf. They become your agent. Very similar to a real estate agent or a sports agent or an entertainment agent. You give them the power to do something on your behalf, okay? You can have a general power of attorney, which says you can do anything I can do. Now, you can only do legal things with a power of attorney. So you cannot go rob a bank and then when the police show up, go, oh, go arrest that person over there because I was doing this as their agent under power of attorney. No, you can't do that. Okay. You can also have a specific power of attorney, and a specific power is where you say, oh, you can only do this certain power. So you can do anything I can do or only a specific one. The most common example of a specific one is if you were selling your house, you're going to be out of town on the day of the closing, and you're worried the market's not as strong as it was and it might get worse. And you say, I really want to make sure this closing goes through, but I'm not going to be here. So I'm going to give someone a specific real estate power of attorney for this one day and for this one closing, for this one property to sign my name to make sure it goes through. That would be the most common example of a specific power of attorney. All right. The most common powers of attorney that I deal with are medical powers of attorney and financial powers of attorney. Most of the powers that people want someone to help them with fall into those two categories, one or the other. That's how we break it down. The reason we break it down into two separate ones is because those are very different skill sets. Dealing with the logical, cold, calculating, monetary situations is one set of skills. Dealing with the emotional, life-changing, possibly life and death decisions of medical stuff, totally different skill set. It could be that you trust the same people for both, but very often people trust different people for those two skill sets. And so we, for the last, I don't know, 25 years or so, have broken them down into two because they're different skills and different powers and different skill sets, okay? Powers of attorney also fall into two other categories, though. There are immediate powers of attorney. As soon as you sign it, your agent has the power. And there are springing powers of attorney that spring into effect or come into effect upon some condition, like when I become incapacitated. How many people think immediate power of attorney is the way to go? I see no hands, nobody saying anything. How about springing power of attorney? Anybody think springing power of attorney is the way to go? Couple hands. Okay. I've asked that question probably 1,000 times over the last 25 years. I've had maybe a handful of people raise their hand for immediate power of attorney. I've had a third of the people say springing. Most people are just waiting for me to tell them, right? I can tell you this, I've done about 7,500 powers of attorney in my career, and I've only done 2 springing powers of attorney. And both times I told the people, I don't recommend this. And I put a bunch of stuff in the file. I didn't recommend they do this. Why do you think that is? So if you have a springing power of attorney, it springs into effect upon the condition. The most common example is when I become incapacitated. This power of attorney is only effective upon the incapacity of the person. That's usually what it says. How do you prove incapacity in the state of Colorado? I'll give you a hint. We already talked about it earlier. It's called guardianship conservatorship. Okay. That is the legal procedure to determine that somebody is legally incapacitated in the state of Colorado. So when you do a springing power of attorney, it sounds good in theory, and it was pretty hot coming out of the textbooks back in the late 90s, early 2000s. But in reality, it's not that great. So the first issue is you got to go activate it. If you're lucky and you don't need the court order, which is the standard default, a lot of times you'll see people put, oh, you just need 2 licensed physicians to certify in writing that somebody's incapacitated, and then it springs into effect. Anybody ever try to get 2 licensed physicians to certify in writing that somebody's incapacitated? I can tell you, we do it every day. It is not easy to do, okay? You got to get appointments with 2 doctors. If you're lucky, you can probably get in to see your primary. And I used to say within a couple of weeks, guess what? Trying to get in for a physical, it's now 6 weeks, but you might be able to get in 2 to 6 weeks, somewhere in that range. But if you go to a specialist, oh my goodness, it's going to be 6 weeks to 6 months, right? And if you're going in for a neurologist because you don't have the capacity anymore, that's a specialist, okay? So you got to get 2 of those. You got to get them to diagnose you, which means you better not have a good day on the day you go to the doctor. You got to get them to agree, and then you got to get them to certify in writing, which means they're legally liable for whatever they put there, okay? Guess what? Doctors hate doing these letters. It's extra liability. They don't get paid any extra, and it takes time. So they're doing work for free, taking on liability, not getting paid. Sound like fun? No, it's not. So they don't like doing these letters in the first place. You can get them, but it takes a while. The whole point of this being, if you have an emergency and you're like, I got to use the POA to pay the bills and make decisions, are you going to have time to run around and do all that stuff? No. Here's the really funny part. Who's heard of HIPAA? Oh my goodness, it's been like 15 years, right? HIPAA is the federal privacy law. The only person who can get your medical information is you. So when we go to activate these powers of attorney, you got to activate them in order to get the information, but then you can't get the information under HIPAA till after it's activated to authorize you to get the information. It's a catch-22, right? You can't get out of the circle. Can't get the information without activating it. Can't activate it without the information. Terrible problem. So you can kind of see where I'm going, but let me ask you, here's the nail in the coffin. Let's say you do have a springing power and your agent waits 5 years and then it activates, right? We got it activated. Can they still steal all your money? Which is what we're worried about when you say, oh, springing power of attorney, I don't want them to have the power right now. I'm afraid they might steal my stuff today. I only want them to have the power in the future when they need it, right? Well, what you're worried about in reality is I don't trust my person. If you don't trust the person you're given, you shouldn't give them power of attorney, right? That's a major problem. They can still take advantage of you. They just have to wait a little while till it activates. In reality, if you don't have somebody you trust, you don't give out powers of attorney, you use different tools. That's one of the things we have to deal with. And that's why trust becomes so popular. That's our third tool. Sorry, I'm coming off a little bit of a cold here. Got a little tickle every once in a while. So our third tool is trust, okay? And trusts are certainly not right for everybody, but they are becoming more and more popular all the time. Interestingly, people think trusts are the hot new thing, and they started becoming popular about 50 years ago. Certainly in the last 25 years, they've become very popular. But trusts are actually older than wills. The first trusts started about 2,000 years ago with the Romans, okay? And they started like this. The Roman soldiers would go off to war. They would leave some steward in charge of their estate and their family, and they would say, it's in trust. You take care of them. When I come back, you will give it back to me. And if you don't do a good job, I will kill you. And that's how it goes. And so that was the first trust about 2,000 years ago. Over time, they've evolved. There are famous trusts. I mean, the Rockefellers, Kennedys, of course, they all do them. Shakespeare set one up in the 1600s, probably the most, and it's still going on today. Billions of dollars in that one. Probably the most famous trust is the King's Trust in England, right? Has over $1 trillion in it. Buckingham Palace, the crown jewels, all the different castles, all of that stuff, part of the King's Trust. The beneficiaries of that trust are the members of the royal family, and depending upon what their position is in the family, each title and whatever has a beneficial interest. You get to live in this castle, you get to have these jewels, you get to do these things. That's what that is. Excuse me. So there are trusts that have been out there. They've been out there a long time. And yes, Rockefellers, Kennedys, Kings all do them. But trusts can also be a very powerful tool for the rest of us, because when you do a trust, you use a private contract. You pick the same people to be in charge that you do for wills and powers of attorney. You give away the same assets to the same beneficiaries, but you have this private contract that does not have to go to court. So we skip probate, guardianship, conservatorship, still picking the same people to be in charge. We skip all the time and all the cost, okay? And you give away the same assets to the same beneficiaries with this private contract called a trust. So if you think about that, it's a very powerful tool for dealing with a lot of the problems that we face in this area, which is why it's become so popular over the last 25 years. Okay, the most common type of trust is what we call revocable living trust. Probably 90% of all trusts are revocable living trusts. The beauty of that type of trust, when you create a trust, there's 3 parties to the trust. There's the settlor, that's the person who creates it. That's the only, and sets the terms. That's the only person that can revoke it or amend it. No one else can do that. There's the trustee. The trustee is the manager of the trust. They're in charge of doing whatever it says to do inside the terms of the trust. And then the beneficiary is the third party, and the beneficiary gets the benefit of whatever's in the trust according to the terms. The beauty of the revocable living trust is you can wear all 3 of those hats to start out, which means you have full control, right? I'm the creator. I can revoke this, amend it, or change it whenever I want. I can put stuff in and take it out whenever I want. I'm the trustee, so I'm in charge of doing whatever it says, give myself whatever I want. And I'm the beneficiary as long as I'm alive, which means I get the benefit of whatever's in there. But if something goes wrong, if I get sick, somebody else can take over, manage my assets for me, and use them to take care of me. And they have not only the power to do it, but they have a duty and a responsibility to do it. They must do it. Unlike a power of attorney, you can do nothing. Hey, I got the power, but I don't have to do anything. I'm too busy. I'm too tired. I don't like you anymore. Or you can take everything and do whatever you want. I can go to Vegas, put it all on black 26 and spin the wheel. I can buy a Lamborghini and drive off to Mexico. I can do whatever I want as long as it's legal. Those things are legal. Okay. So power of attorney, very risky tool, not a guarantee that things are going to go the way they're supposed to. Trust, rules and guidelines, duties and responsibilities. You must do certain things like take care of me and use my assets for my benefit. You must not go buy a Lamborghini, go to Vegas, or do whatever. So much more powerful tool when we talk about how are we going to be taken care of if we become incapacitated. Okay. And then, of course, if we pass away, yes, someone can take over and make sure it gets wherever it's supposed to go to my family without having to go to court for probate and all of that. So very powerful tool for staying out of court and avoiding a lot of those problems that every one of us face every single day. It's also a very powerful tool. You know, one of the other hot topics I deal with, I did 2 appointments today on this, asset protection. Everybody's getting sued for everything, right? All those billboards, all those TV commercials, every bus, every magazine, every radio commercial. Have you been injured, right? So the liability through the roof, everybody's getting sued. Well, asset protection is the other side. If I have a problem, how do I protect my stuff so I don't lose it, right? Well, your kids are running around and your grandkids, of course, they're not as wise. They're not as careful. Youth is wasted on the young. They run around and do reckless and silly things. And of course, even if they're doing good things, sometimes bad things happen. And so asset protection, how do I protect my kids and grandkids so they don't lose everything I spent my whole life accumulating to give to them in one shot? The best way to do that is put it in trust. If they don't own it, they can't lose it. So you can hold it in trust for them till they get more responsible, till they get older, till they get their affairs in order, till they demonstrate certain amounts of wisdom and life experience or reach certain ages or milestones. So it's a great tool for protecting. And so one of the questions, can I have a trust active if you die? Yeah, it can continue on after you're gone, and you can still have some control even after you're gone and protect those beneficiaries if you need to. So there's 3 huge benefits. What happens if I die? What happens if I get sick? And what happens to my beneficiaries? Trust covers all of those. It can cover like 1 million different scenarios. Okay? That's why it's such a valuable tool. Certainly not right for everybody, but that's why they're becoming so popular, because they do a lot of different things. Okay. I'll touch on one other hot topic here, and then I'll kind of open it up for questions. Anything that I didn't cover that you came here to hear about, anything that was confusing, stuff like that. And that's the long-term care issue. One of the things I deal with is who's in charge of all this stuff, and how legally, how do we take care of it all? Who takes care of me? Who takes care of my stuff? But the long-term care issue is who's going to pay for it all. Okay. When we talk about long-term care, we're talking about if you need care that is more than about 100 days, that's called long-term care. So short-term care, I got sick, I had an accident, broke my arm, got an illness, whatever, you go to the hospital, that's covered under your regular health insurance or your Medicare, which is your government health insurance when you turn 65. If you're under 65, it's covered under the insurance you get either through your job or the stuff, the Obamacare that they make you get now. That's health insurance for short-term care. If you go over 100 days, that is not covered by your health insurance. That's long-term care. And the most common example, you got to go to a nursing home. You can't live by yourself anymore. You can't take care of yourself. That's long-term care. The average cost for a nursing home right now in the metro area is about $10,000 a month, about $120,000 a year. Okay, so it's a big deal, and it goes up every year. Most people I know cannot afford to pay that amount without dipping into their assets pretty substantially. Okay. It's hard to generate 10 grand a month of income when you're in retirement, and bleeding $120,000 a year, it's going to chew through your assets pretty quickly. The average stay for someone, most people either go into a nursing home, get better and come back out. I broke my hip, went in, rehabbed, came back out, or they go in, give up within 6 months, pass away within 6 months. But for the people who don't, the average stay is about 3.5 years. So if it's 120,000 a year, you're talking about a $350,000, $450,000 issue here. Okay. That's a wipeout for a lot of people. And so a lot of people say, well, how do I save my stuff? And who's going to pay for me? And that's where we get into Medicaid. Medicaid is the government welfare program that says if you run out of money and you can't afford to pay for your care, the government will pay for you. But as I mentioned, it's welfare. You got to run out of money. Okay. So they'll pay the 10 grand a month, but they don't pay it till you don't have the 10 grand a month anymore to pay yourself. And you cannot give your stuff away and then say, I don't have any money. I give up. Take care of me. The government can't afford to pay for everybody. So there are super strict rules. There's a 5-year look back period. There's an unlimited penalty period. It's a huge deal. So one of the first things we have to do when we sit down and we say we're going to do planning, we have to decide, are we going to do traditional estate planning? I'm going to keep my stuff. I'm going to use it for as long as I can. And then I want to pass it on to my family as efficiently and quickly as possible with as little cost as possible. That's traditional estate planning. Or I'm afraid I'm going to run out of money and I want to try to save whatever I can, but I'm going to run out before I die. Well, you can't plan to keep your money till you die and plan to run out of money before you die. You can't do both. They're opposite directions. So you got to pick one. That's one of the biggest changes we have over the last 20 years. We have to decide which way we're going because it's a huge deal. If you try to sit down the middle, you're going to get crushed. Okay. You'll get run over by the train. All right. So I'm going to go to questions here. As I mentioned, as part of coming to the class tonight, you all have the opportunity to do a consultation with me. Janice is going to give all the information. You can reach out by phone. You can reach out by email. You can go to our website and fill out an intake or a questionnaire there. Any of those ways you can reach out if you want to. Okay. All right. And then I'll open it up for questions here. Let's see. Is it necessary to file a copy of a will or trust or both with the courts in the county? So wills must be filed with the probate court within 10 days of somebody passing away. Trusts are private. They are not filed. There are occasionally times where you would do it for some specific purpose, but 90 to 95% of the time they are private and they are not filed with any court or county or anything like that. Who should not have a trust? Goodness. That's probably a loaded question. It's something you would look at on a case-by-case basis. If you don't have any assets, you wouldn't need a trust. If you're not trying to save anything or protect anybody, if you're not worried about your own care, I suppose you could not have a trust. Those are all the different reasons that you would have a trust. So if you didn't have any of those reasons, I mean, I've got people, they are single, 22, they have a bicycle and a checking account with $500 in it. They do not need a trust. If you have kids, if you have assets, if you are above the age of 40 or 45 and bad stuff can start happening to you, excuse me, those are all the times that you would try to have something and a trust starts to make sense. If you're not married, but you have a partner, is there a benefit to a power of attorney, or does having a trust cover everything? So generally speaking, when you do a plan, you're either picking a will-based plan and you're picking a trust-based plan. Okay. Either way, you're going to have all the peripheral documents that go with that. If we do a trust-based plan, we will still have a will and powers of attorney, but they are all backups to the trust, which is the big bucket. We put all your stuff in the bucket, and then the will, the powers of attorney all point to the trust as backups and safety nets. But the goal is for the trust to do 90, 95% of the heavy lifting, which it does about 90 to 95% of the time. So when you do any plan, it's not any one document. We're trying to cover a whole bunch of things that could happen. So you're going to have a basket of documents that you're going to do as part of the plan, depending upon which plan you pick. And that's part of the process. We got to identify what are the issues, what are the goals, and what are the tools we're going to use to try to address those. Okay. What's the typical cost of a trust? It depends on what type we're doing. Most of the revocable trusts that I do, they can run anywhere from $2,500 to $7,500. I would say the vast majority are in the $3,000 to $5,000 range. We are pretty mid-range. Downtown firms charge twice what we charge, so they can routinely be $8,000 to $12,000. We don't have that kind of overhead, so we don't have to do that. We are not the cheapest on the block, but we also know what we're doing. A lot of the people that say they will do it for $1,500 to $2,500, which is about the cheapest you'll see, they don't know what they're doing and they have terrible stuff. LegalZoom, terrible. Quicken Lawyer, terrible. Things are way too complicated these days to do a computer program. You answer 20 questions and it spits out some stuff. It's just not, it's like, I mean, I used to change my own oil, change my own brake pads. I open up the hood of my car now. There's a whole bunch of lights whizzing and whirring. There's things, I don't even know where the dipstick is for the oil to even check it anymore. And everything has a sticker on it that says, if you break this seal, you void the warranty. I gave up because I don't want to be driving down the road. My engine blows and they're like, oh, you're not under warranty because you did this. And now that's $10,000 or whatever. It's kind of like that with these. By the time you're all said and done, it comes out to a few $100s a document, whatever plan you pick. And if you save a few $100s and you screw it up, it's going to be $30,000, $40,000, $50,000 or more. And it's just a disaster. So I don't recommend that stuff. You want to get it done by somebody who knows what they're doing and do it right. I mean, we're talking about what happens to you and all the stuff you spent your whole life. It's kind of a big deal. If we have a will, are you recommending that a trust be done as well? Well, so if you do a trust-based plan, we got to have a will that matches it and goes with it, okay, and refers to it and all of that. So yeah, you wouldn't take your old will that didn't have a trust and try to blend that in. It would take more time and cost more money than just having the will that goes with the trust already. So we have kind of a package of stuff. For an individual, it's usually about a dozen documents. For a couple, it's about 15 or 16. So it's quite a comprehensive thing. We got to cover a million different scenarios. So that all goes together and it all matches. And you don't want to pay $400 an hour for me to figure out what you did right, what you did wrong, what the old person did, and try to modify it because it would take dozens of hours. It's a terrible deal. So what we do is just do it correctly from the get-go and go that way. All right. Other questions? Looks like we got about 5 more minutes, maybe. Anybody else have any questions? Yes.
Okay, so we should probably get a will started that has a POA in there, all versions of POA, medical, regular, immediate, springing, all of that, if that's what's needed. And the will should include a trust too, just in case. We should just have all these set up kind of ahead of time.
Yeah, I mean, well, so the whole purpose is, good question, you want to have it done before something bad happens. When should I do this? Before something bad happens, right? We don't know when that's going to be. Could be Terry Schiavo was 26, okay, down in Texas. So could be at 26, could be 86. We don't know. So the point being, at some point, I would say the likelihood of something bad happening when you get into your 40s, bad stuff starts happening. I lost 3 friends in my 40s. I've lost 2 already in my 50s, early 50s here. Every decade, it gets worse as you go up the ladder. 60s are worse, 70s are worse. Sometime in your 40s, you should be looking at, if you don't have anything in place, you should be looking at it. If you have kids, you should be looking at it. It can happen anytime. And if you have assets you want to protect more than a bicycle and a bank account, certainly if you have any real estate, certainly if you have more than a few $100,000 of assets, actual assets, that's when you start looking at doing a plan of some kind. If you do a trust-based plan, you're going to have all the other stuff that goes with it, wills and powers of attorney. If you do a will-based plan, you'll have wills and powers of attorney. You just won't have the trust part. So yeah, you can do it either way. Okay. What's the best way to get ready for a consultation? So usually, these aren't killer or anything. We do 20, 30 minutes. We can do them by Zoom. We can do them by phone. You can come on into the office if you want to. I still like to meet in person, but you can certainly do them remotely and save a trip. We visit for about 20, 30 minutes. I want to get a ballpark picture of you, what you're concerned about, what your goals are, what the issues are. I want to get a ballpark picture of your assets. What do you have? What's it look like? Where is it? What is it? And what's it worth? Just ballpark. And then we can look at, here's the different issues I see. Here's the different ways I would address those. I can usually give you a couple different options of different types of plans, tell you a ballpark figure of what those would cost. And that gives you a pretty good idea. Then if you want to do something, great. If you don't, that's okay too. We got plenty to do. So that's probably the best way to get started. If you make an appointment, they'll send you an intake sheet to kind of get that ballpark picture of stuff. It's 1 page. It's pretty easy to do. Not too bad. Did I hear correctly that trusts are not impacted by probate? So yeah, trusts. So the reason you go through probate is to get the assets out of the name of someone who has died. Okay. If you set up a trust and put your assets into that trust, then when you pass away, you don't own any assets. We don't have to go to probate. Trusts don't die. Trusts don't go to probate. So if you do that, you're not going to probate. That's how that works. Okay. So trusts are not impacted by probate. Yeah, they are outside of the probate process, and they that's the purpose. That's the whole point. That's the whole point. Okay. Is there prep work to develop a trust you can do to use your time that's the best? Yeah, I mean, not really. So the kind of the way it works is we would do an initial consultation, identify the issues, kind of come up with some options for the plans. Then you would pick which way you want to go. Then we would start getting detailed information from you once we get going and you say, yeah, I want to do something. And we would flesh all of that out. Then I would do drafts of everything, which we would take a stab at, okay, here's what I think you want, and here's what it's going to look like. Then we would do a follow-up to answer questions, make tweaks and things like that. And then at some point you would tell me this looks pretty good, and we would go ahead and sign everything. So that's kind of the process. I don't get into the details till we actually get going because we don't need to right now, but we would certainly get into those at some point as we go along on the process. So yeah, we have different steps where we give you different things that we want from you and stuff like that. When do beneficiaries come into play with probate if all the assets are covered by name and within a will? Well, so with the will is the instructions to the judge on what to do in the probate court. And so when do beneficiaries come into play? When you go to probate, the first step is to get appointed as the personal representative executor. Then you got to send out notice to all the beneficiaries, and you got to give them an inventory of the assets, a copy of the will. Here's what you're going to get, all this stuff, different notices as you go along. Then we got to deal with creditors. We got to go get control of all the assets, pay off the debts. And then at some point we distribute what's left according to the will to whoever it says is supposed to get it. So throughout that process, the beneficiaries are going to be notified about 5 or 6 times over the course of that 12 to 18 months. And that's why that's the process. That's why it takes a certain amount of time. The people running around doing it, by the way, when people are like, why does it take so long? The people running around doing it all as the personal representative executor, I promise you, they don't go, wow, this seems like they're running around and they're like, man, can I have more time? Can I have more time? I only 30 days to find out all the assets. I don't even know what they had. How am I going to do that in 30 days? Then they run around. Oh, I only get 45 days to do this, 90 days to do this. How am I going to do all this in 90 days? I got to go clean out the house and get it sold in 90 days. It's a 45-day closing. Once you get a contract, you got to get it listed. You got to get it under contract. That takes time. And I got to get it cleaned out. How do I do all that? I have a job during the day, you know, I got to do this on nights and weekends. How am I going to, it takes time. It takes more than you think. Okay.
Okay, one more.
Yeah, one more. Sure. Go ahead.
Okay, so I did like a DIY will with some company that came with my taxes. Is that liable? Does that stand up anywhere? Even though I don't plan on going anywhere anytime soon, does that cover anything if I did a living will and a standard will now through
Sure.
some DIY document?
I wouldn't know without seeing it, but I kind of touched on that earlier. I do not recommend that. Those little questionnaires and programs they do are super, super basic. Most people don't know what they're doing when they try to answer the questions. And so they routinely make mistakes. So is it legal? Possibly, if you executed it correctly, it could be legal. I can tell you, you can make a will by writing on a napkin in a bar. You can just write whatever you want to write. There was a
That's
famous
true.
case about 10 years ago. An actual celebrity in town hit somebody in his car on a bicycle and killed him, knocked him off a cliff, was so distraught, they went down to a bar in the Denver metro area, got hammered, took a cocktail napkin, wrote a bunch of stuff on it, and then killed themselves. That cocktail napkin was found to be a valid will. Okay. Went all the way to the Supreme Court. So it was legal. I can tell you, I wouldn't recommend that for a lot of reasons, but the biggest reason was it didn't address most of the questions that need to be answered, and it was unclear who was supposed to get everything. That case went on for 7 years. It cost over $40 million of litigation to determine who got it, because there was 2 groups saying, we think he means us. No, we think he means us. And at the end of the day, it was a disaster. Okay. But it was held to be a valid will. And so, yes, could it be legal? Yes. Does that mean it's good? No. Like, oh, is this knockoff Chinese cell phone that looks like an iPhone? Is this a real cell phone? Well, sure. It looks like it powers on. Is it good? Probably not, right? The things they make in Bulgaria or whatever, I don't know, but you probably don't want that. So there's a difference between, is it a real thing and is it good and is it going to do what you want? What I can tell you is when you're saving a couple $100 and the cost, if you're wrong, is going to be $400 an hour for dozens and dozens and dozens of hours, the risk reward ratio is pretty out of whack. Oh, I saved $200. If I'm wrong, it's going to cost 20 to 50,000. It's a lot of problems there. Okay, so I don't recommend it.
Thank you.
So no probate for a trust. When does it take effect? Yeah, so trust takes effect as soon as you sign it. Okay, and then it has different stages depending upon if you're healthy and you're in charge, if you get sick, or if you pass away. Okay. All right. I think I'm running over here a little bit, but lots of good questions. I appreciate you guys coming out. I will turn it back over to Janice and let her wrap it up.
Yeah, thank you so much, Frank, for that presentation.
Thank you.
Yeah, there were a lot of good questions coming in, and I hope everybody got the information that they were looking for. Once again, I know that Frank mentioned it earlier, but I will be sending out an email with a PDF and a whole bunch of information about Frank. Lots of information about like trust, wills, everything that he covered. And there also will be a little card with information about getting your free or complimentary 30-minute consultation call. If you don't see that email from me, at least by the morning, feel free to reach out. But once again, this video will also be on YouTube, and I'll also be sending out a link for that so you can rewatch it at any time. If you have any questions, you have my email, feel free to reach out. But thank you again for joining us